Welcome back to Legal Risk Today. My name's Stephen Carris. I'm here with Chris Kirkblythe, CEO of LBS Legal. Chris, just before the break, you gave us a bit of background about exactly LBS Legal's role in supporting law firms in the UK in relation to what you deem as a sort of a heavy burden of risk and compliance regulation. Just sort of taking us on to the next point I want to raise. What then would you say are the main risks to solicitors and the public when dealing in legal affairs nowadays?
Well, in fact, the risks to the public, the consumer protection measures in place for members of the public instructing solicitors are extremely comprehensive. First of all, obviously, the whole profession is very closely monitored and regulated. So clients can feel comfortable knowing that when they walk into a solicitor's practice, they're walking into a business which is properly monitored, scrutinised and overseen. All solicitors carry very extensive indemnity insurance. It's a unique form of indemnity insurance which insurance companies, unlike most policies, cannot avoid paying out on. So clients' money is very well protected. Sitting behind the indemnity insurers as a last resort is the SRA's compensation fund. So I think the consumer protection measures are very comprehensive and the public can feel very comfortable instructing solicitors.
No risk at all to the public. It's a risk-free environment if you're.
There's a risk every time you walk out.
What's the point of the SRA if there's no risk?
Well, one of the reasons why consumers can have confidence in the profession is because of the SRA. So, although I am a critic of many aspects of the SRA's management and approach, of course, the legal profession needs to be properly regulated. So, of course, there is a proper role for the SRA. The major risks to solicitors in practice is a huge question, a very difficult one to answer. There are a whole range of financial risks, reputational risks, regulatory risks, strategic risks, operational risks. The list goes on. And one of the major failings of individuals who set up in business as a lawyer is that they often don't understand those risks and they often don't analyse those risks properly and they don't have the skill set or the tools to do so. So I think the risk, in answer to your question, I think I would probably need about another 4 hours to talk through the risks to solicitors.
How about 30 seconds? Well, okay, what would you say today? I mean, is it an evolving landscape of risk? I mean, with the increased burden, what are the risks? Is there a risk with the increased burden of regulation?
If I could answer your question by focusing in upon the major risk, as I perceive it, to owners of law firms in regulatory terms. So what I mean by that is, if you own a law firm, what is it that you're likely to get into trouble with the SRA for? And our analysis shows that you are most likely, unless you're a crook and you intend to steal some client money, which I'm going to assume that our listeners are not, then you are most likely to get into trouble for failing to run a proactive system of risk and compliance throughout your firm. One of the quite revolutionary changes, which was introduced in 2011, was SRA Principle number 8, which requires you, amongst other things, to run your business effectively and in accordance with sound principles of risk management and also financial management. If you don't know what those sound principles of risk management are and how they ought to be worked through within your business, then you are already guilty of misconduct. You don't have to do anything wrong. That is wrong, because that is a breach of one of the SRA's fundamental principles. And the allegation which is most difficult to defend is this allegation that you have failed to run your business in accordance with sound principles of risk management. Why is it difficult to defend? Firstly, because it's incredibly broad in the way that it's drafted. And secondly, when the SRA are making that allegation against a manager in a law firm, they always do so with the benefit of hindsight. Something has gone wrong within the firm. Something has happened to the firm. Most likely it's employee misconduct. And most likely that employee is being disciplined separately. But the question that you as an owner of a law firm will be asked is, why did you not see this risk coming? Where is your documented consideration of this risk? Where is the list of control measures that you put in place to mitigate this risk and to bring it within acceptable parameters? Where is the audit trail? Where are the stress tests that you did to test the effectiveness of those control measures? All of these questions are extremely difficult to answer. And therefore, the SRA really has quite a free hand and can bring this allegation. Some research that we carried out showed that in 102 out of 103 cases, the SRA did make that allegation, amongst others, against managers within law firms. So the biggest regulatory risk faced by managers in law firms today is that they fail to develop and implement a fully comprehensive program for risk and compliance within their business. That's my 30-second answer.
So irrespective, I suppose, of their actual principles or ethics, their behavioural, their attitude, if you will, towards their clients. Of course, we understand that client care, the duty of care to your client, you've already emphasised that, is paramount. But aside from that, aside from direct dealings with the client, even if the client has got no problem with their solicitor whatsoever, they're happy as anything, they've got a history of a very happy client base, very few complaints. That in itself, what you're saying, that in itself will not necessarily protect firms from the attentions of the regulator. It's more to do with
because if
they're not having systems in place.
If you're a manager within a law firm and you care passionately about the interests of your client and you're good at your job and you understand your practice area very well and you achieve great results for your clients and your clients never complain and there's never been a negligence claim against you, so you're getting all of those things right, and that's great. But if you don't, as well as doing all that, implement a proper program of risk and compliance throughout your entire business, then you are in breach of Principle 8. That is a serious misconduct. And the SRA will deal with it as such. So, those lawyers historically would have been safe from disciplinary harm, but they are not safe from disciplinary harm now. If something goes wrong within their business, they will be challenged on Principle 8. They will be challenged as to, why didn't they see it coming? What had they done about it? What control measures were in place? And if their answer is, I'm too busy doing a fabulous job for my clients, it's not good enough. It won't work.
So is it fair to say then that there must be surely fewer unethical rogue, if you will, solicitors practicing out there today under the current model of regulation? Surely that must be the case now. We must have seen.
Well, there are more solicitors. Numbers now are exceeding 120,000, which is an extraordinary increase in the number of solicitors, particularly when we consider how many non-qualified people operate within law firms as well. This is a successful profession that has grown extraordinarily and contributes enormously to the success of the economy. Are there more rogue solicitors today than there have been historically? No, I think proportionally.
My question was, are there less today as a result of...
Look, there will always be a small rogue element within the profession, and it's not in anybody's interests that those people are allowed to continue. I would, however, quote with interest a leading QC who has defended solicitors in the disciplinary tribunal his entire career, who recently said that he can count the number of dishonest solicitors he has represented on the fingers of one finger. In other words, there are many, many hundreds of honest, decent solicitors who end up in the Solicitors Disciplinary Tribunal, and there always has been. And that hasn't changed. What I think may have changed is the skill set of the regulatory body to identify dishonest behaviour. There is, I believe, a woefully inadequate bank of expertise within the Solicitors Regulation Authority. They do seem frequently, for example, to be behind the curve when it comes to new areas of fraud, new areas of risk. They don't seem to be particularly consistent or wise in their judgments as to what constitutes dishonest behaviour and what is just unfortunate or accidental or perhaps even reckless behaviour. So I think if you are going to be an out-and-out crook within the legal profession, I think now's a pretty good time to go for it.
Really?
Yeah, I do.
Despite the fact that everything we've said so far with this huge range of punitive powers given to the regulator to stamp out any misconduct, you believe that now is the time for the crooked solicitor to come forward?
I think the SRA's focus is in the wrong place. I think the SRA's focus is all too often on hard-working, decent solicitors who are under enormous pressure and who have made a mistake. And I think they spend, well, I know they spend many millions of pounds investigating and disciplining and prosecuting individuals like that.
I mean, you've dealt with
the old stereotype of the mad, the bad, and the sad.
Yeah.
And I believe the mad and the sad get excessively clobbered, and the bad are a bit too crafty for the SRA, and the SRA lack the intelligence collectively to effectively target the bad and get them out of the profession, which is what we all would like to see.
So you must have dealt with, I don't know, how many solicitors do you think you've dealt with over the last 5 years since LBS Legal was? Many, well,
several thousand.
Okay.
Several thousand.
Would you say then, in your opinion, that in that time coinciding with the shift to this current risk-based model of regulation, I should say principle-based model of regulation, would you say that the SRA's embarked, I think I know the answer to this one, to be honest, on an intense regulation, or light? It's not very light touch, is it? We're talking quite intense regulation here. I know the banks were criticised for being too light touch, which led to the crash. We know that.
Yeah.
And there's no correlation, is there, from what you're saying to that sort of light touch approach? Would you say that they are quite intense then in their approach to regulation?
Well, I've already said that solicitors in England and Wales are the most heavily regulated people in the world, and I would challenge anybody to prove otherwise. Whether that regulation is intense on a day-to-day basis is a difficult question to answer. I think that once you have caught the SRA's eye for one reason or another, then you will certainly experience a very intense, high-intensity regulation, which is very uncomfortable, very difficult to live with. But for the majority of firms, the SRA is not regulating them heavily or intensely until something goes wrong. Unfortunately, the nature of being in business, particularly in legal business, which is fundamentally risky, things do go wrong and things will go wrong. And it's inevitable that every firm at some point or other will come under regulatory scrutiny.
Okay.
And it's just how well you can stand up to it when it happens. Okay. And the way to stand up to it, and I'm sorry if I'm repeating myself, but the way to stand up to it is to have a properly documented program for risk and compliance throughout your entire business.
Okay, Chris, thanks. We're going to take a quick break now. Join us in a moment. We're going to be asking the question, are the SRA institutionally racist? And join us after the break, and Chris here will help us answer that question.